So good evening. I am the director of the Research Center on Language Contact, under which the research group on translation and transcultural contact we're working with. And I'd like to congratulate Andrew Clifford and Maria Constanza for having the great idea of having invited Holly Mikkelson to talk tonight about everything you always wanted to know about court interpreting. I am actually really myself, that's why I'm here, particularly interested in the legal interpretation in the context of the court. As I was discussing with the speaker tonight, interpreting in the court is already an exercise in the first language. So, and usually the context is a context of pain and sometimes death. I mean, for criminal, for example, interpretation. So I'm very fascinating to know what is the role of the interpreter in that layering of delivering a sentence when these people in the room are here to hear about how they're going to lose their freedom, sometimes their property, sometimes their children, and how does the interpreter, not of the legal text, but mediating between the people who are receiving the sentence and the judge and the audience are working in making sure that, I guess, the emotion do not take over the work of translating the sentence. So I'm particularly interested myself, and I'm really looking forward to your talk. So Andrew, do you want to maybe present Holly Mikkelson? So I'm glad you're coming from the States, and I'm delighted to be here tonight.
Thank you, so am I.
Thank you very much, Dominique. It may seem like using a microphone here tonight is a bit of overkill given the intimate number of people that we have here with us today, but you're already in on the secret. This is the first time, actually, that we're having interpretation not just from the room here. We're being interpreted from English into French in the booth at the back, but as some of you are already listening, in another location, not here in the amphitheater, but down the hall in our interpreting lab, we have two other teams of interpreters working, and they're putting my words right now into Spanish and also into Mandarin. If you're interested, some of you have figured this out already, but if you're interested in taking part in this exercise, you can just request a headset, but leave a piece of ID with our technician here so that we do get the headsets back from you, because they are quite expensive. So my name is Andrew Clifford. For those of you that don't know me, I'm the director of our Master of Conference Interpreting, and I have the great pleasure of introducing somebody who is, I'm very pleased to say, no stranger to Glendon or to Toronto. She's been to Toronto a number of times. And we're really thrilled to have here Holly Mikkelson, who is an associate professor of translation and interpreting at the Monterey Institute of International Studies in Monterey, California. I'm a little bit nervous, I'm shaking a little bit, because Holly Mikkelson has to be probably around the world the biggest name on court interpreting, written a number of books on the topic, and a very, very widely recognized expert on the subject. So we're thrilled to welcome her here back to Glendon. Actually, this is not her first time here. And without too much further ado, I'm simply going to turn the floor over to Holly.
Thank you, Andrew. And Dominique and everyone for coming here. Thank you for inviting me and making it possible for me to be here. My talk is going to be about court interpreting, as you can see from the title. Everything you always wanted to know about court interpreting, maybe more than you ever wanted to know about court interpreting. I don't know how curious you are about court interpreting, but we shall see. So what do court interpreters do? And before I get into what they do, have any of you ever interpreted in court? Yes. So you already know what court interpreters do. It's a very challenging job, and it's especially so in a system of adversarial justice, which we have in Canada and the United States in the common law system. And what interpreters do is allow a defendant, someone accused of a crime, or someone who has been sued in a civil action, to be linguistically present at all stages of the proceedings. If you have a constitutional right to be present when you are being tried for a crime or when someone is suing you, you can't be present if you don't know the language of the court. So interpreters make that presence possible. They also enable the court to understand testimony by people, either parties to the case or witnesses or the defendant, who do not speak proficient, in our case, English. We use the term LEP in the US. I don't know if that's used here, but it is limited English proficient. And we deliberately use that because it's not that no one knows a single word of the language of the courts. It's that they don't feel comfortable functioning in the language of the courts, and they don't feel confident that they would be able to understand and fully participate in their defense if they are not fully proficient in the language. It's unfortunate that many English speakers of any sort do not have their own interpreters into plain English, because the language of the courts is practically impenetrable for anyone who is not trained in the law. So what interpreters do is make that language available to someone who does not speak the language of the proceedings. In Canada, that would be either English or French, depending on what province you're in or what the language of the proceedings is. But if they are not completely proficient in that language, they need to have access to it, but that doesn't necessarily mean that they are going to fully understand what is going on. Many, many people, ordinary people with a normal education, the average for their country, go into a court system and have no idea what's going on, even if they're fully fluent in the language. And for me, as a well-educated person, having grown up in the United States, watching all the TV shows about the court cases, even I had trouble understanding what was going on when I first went to court. So unfortunately, a lot of what interpreters do is not making things understandable. It is just making the message available to people, but they may not necessarily understand it because of the legal complexity of it. It is equal access for justice, but that does not mean equal understanding. And that's a big difference that people need to be aware of with court interpreting, because we do not adjust the message according to the level of understanding or what we think the understanding would be of the listener. Where do court interpreters work? They work in the courtroom, which is what most people assume, but they also interpret in any kind of legal proceeding that takes place in or out of a courtroom. And they may interpret for a defendant who has a right to hear all of the proceedings, in which case they would be sitting at a table next to the defendant, interpreting everything for them. Or if it's a witness who doesn't speak the language of the court, they would be up on the witness stand with them right next to the judge, interpreting their testimony. They also interpret in attorney-client conferences, and that could take place in a law office or in a small conference room at the courthouse or even at the jail. So interpreters go to a lot of different places. They may go back behind the courtroom to the judge's chambers. They may be out in the hallway, which is a very difficult place to interpret because it's noisy and chaotic. But a lot of times, the attorney will need to give a very brief notice to the client about something that has changed in the case or some new information that has come up. So you could be interpreting anywhere, even in a holding cell. When people are brought from the jail for their court appearance, they keep them in a little temporary jail in the courthouse specifically for that purpose. And in our system, that's called a holding cell. So interpreters may be in the jail or in the holding cell, which are not very pleasant places to be. As I said, they may be in a law office. They may be at some ancillary department associated with the court, like the probation office, where people go to be interviewed to determine their situation if they are on probation. Or they may interpret at a counseling center. People who have problems with substance abuse or with anger management are often ordered to receive counseling as part of their sentence. And if they don't speak the language of the court or the official language of the country, then they need an interpreter there too. And if that is something that's ordered, that they have to comply with, then an interpreter has to be provided for that. So you might find yourself doing more like mental health interpreting, group therapy, or individual counseling. Interpreters now also provide their services over the telephone or more likely on video. There are many court systems that rely on remote connections in order to either to save funds because of transporting people back and forth, or to be concerned about security. Instead of bringing people from the jail to the courthouse for their proceedings, they stay back at the jail, and the court has a remote connection to them so that they can communicate with them and never take them out of the jail. And interpreters are more likely to be in the courtroom seeing the interpretee on a screen at a distance, which is another sort of challenge. And the interpreters who are in the lab right now have this really extreme challenge of interpreting me without being able to see me, I believe. And that is really difficult for an interpreter not to be able to see the speaker. So if there is a video connection, that always improves things somewhat, but it's never as good as having people there in person. So what is the day-to-day work of an interpreter? What are we expected to do? We render everything that is said, whether it's in court or in any other one of these circumstances that I mentioned, everything that is said in the source language, and we render it into the target language, that is the language of the defendant or the witness. Or in the case of the court, when we're interpreting into English or French, it would be, the target language would be the language of the court, and we're interpreting the witness's statement. So the source and target language will go back and forth, and all of the interpreting that's done in court is bidirectional. Interpreters have to be equally fluent actively in both languages. And accuracy is particularly important in court proceedings. We cannot distort the meaning in any way because people's credibility is being judged based on their representations in court, which means that a judge or a jury is looking at the person and listening not only to what they say, but also how they say it. And a lot of times, nuance of speech is critical in deciding whether someone is being truthful or whether someone is terrified or if they are incapable of understanding something. So it's important for the interpreter not only to convey the essence of the message of the speaker, but also the tone, the manner in which they have uttered that message, without omitting anything. And by that I mean that things like uhs and ums are not omitted because they are part of the manner of speaking of that person. and they are part of what we look at when we judge someone's credibility. We also don't omit unpleasant things or foul language. Sometimes people say things in court that are not pleasant, are not the kind of language that you would expect to hear in a formal environment, and that has to be conveyed. Suppose you have a witness who saw an assault, and they're testifying about the words they heard exchanged between the victim and the assailant. If there was swearing or racial slurs or something like that, the interpreter has to reproduce exactly what the witness said, or the jury or the judge will not get a true picture of what happened. If they omitted racial slurs or any other kind of biased or bigoted language because they were too embarrassed or because they thought it would be offensive to the court, then the jury would not get the whole story. They wouldn't have a true sense of what this witness was describing. We also cannot add anything. We cannot explain something that we think might not be clear because it's obscure legal language. We have to interpret it exactly the way it was said. So if an attorney says something like, when you were traversing the paved portion of the roadway, what did you visually observe? That has to be rendered exactly that way, with that high register formal language, rather than just, what did you see when you crossed the street, which is what is meant. But it may be that the attorney is deliberately trying to confuse the witness, deliberately using high register words that the witness won't know for their own reasons. And that's something that the interpreter should not distort. So you cannot change the style or the register of the speech. So we've already heard some terms, and if you are interpreters already, I don't know if everyone here in the audience is already working in the field, but target language is the language you're interpreting into. Source language, the language you're interpreting from, and as I said, in court it's bidirectional, so you're switching back and forth. Interpreting refers to the oral rendition of a message that is spoken or that is signed, and translation, of course, refers to the written transfer of messages from writing to writing. Although a lot of times interpreters end up doing a hybrid of that, which is sight translation. They have a written source and they convert it into an oral target text. Interpreters perform consecutive interpreting, which means you wait until the speaker has finished and then you begin your interpretation. And they perform simultaneous interpreting. In some countries, there is no simultaneous interpreting in court proceedings. It's all done consecutively. But what that means is that all of the proceedings are not interpreted completely for a defendant who doesn't know the language of the court, but rather they get a summary afterwards. And in the US, and I believe in Canada also, that is not acceptable. People should not hear a summary after the fact of a proceeding in which they are involved. So interpreters have to be able to perform simultaneous interpreting, but it's simultaneous whispered interpreting. We don't have booths in the courtroom, so the interpreter has to sit in close proximity to the listener and speak into a mic with the listener hearing their interpretation on headsets. And those are much more difficult conditions to work in than if you have a soundproof booth with the input coming through your own headsets. Court interpreters work in difficult environments because courtrooms may have a lot of different things going on in them. And you have to perform this simultaneous whispered interpreting with a lot of distractions, people walking back and forth, people talking, shuffling papers, rattling chains if they're bringing people in from the jail. So it's a very challenging environment to work in. And as I mentioned, there is sight translation. A lot of written material is given to people which they have to read and sign, or which explains their obligations or their rights. And all of that material has to be sight translated into the language of the person. There also may be documents from another country that are brought in as evidence in court, and that has to be rendered orally for the record. In our common law system, everything is done orally. So when there are written documents, they have to be read out loud so that they go into the transcript of the proceedings. There is a difference in the kind of interpreting that is provided when you are interpreting for a defendant in a case, or in a civil action. It could be either the plaintiff or the defendant, as opposed to interpreting for a witness in the case. Witnesses don't have the same rights that the parties to a case have. And that means their testimony, which is only rendered in the consecutive mode, and it is rendered into the language of the court, that's the only time that they have an interpreter provided for them to interpret all of the language of the court for them. Once they leave the witness stand, they don't have a right to have the interpreting for themselves. If they are interested in the case, they may be a victim or they may be a relative of someone involved in the case, but they're not entitled to have all of that interpreted for them. Only the accused or the plaintiff and defendant have that right. In their case, they do have all of the proceedings interpreted for them. And that means motions, objections, arguments, any kind of comment that anyone makes, any aside, whatever happens in court during that person's case should be interpreted for them in the simultaneous mode. And that adds another challenge to what the interpreter has to be able to deal with, because you have a huge range of registers of speech that have to be dealt with. You have the formal legal language of judges and attorneys who most of the time use very technical legal terms, but occasionally they will lapse into some colloquial expression, or they even tell jokes on the record. They will quote from someone's testimony and use very colloquial or even vulgar language. And all of that has to be rendered accurately in the same register. If you have a police officer testifying on the stand, they speak in their own particular way. You may have a chemist testifying on the witness stand. They have their own peculiar way of speaking. And all of that has to be rendered at the same level by the interpreter into the target language. So the interpreter has to be prepared for a huge range of different kinds of language. Every element of meaning must be preserved. We take an oath when we go into court that we will interpret accurately and completely everything that is said. And a lot of people think that what interpreters do is verbatim interpreting. But what we really do is interpret meaning, accounting for every single element, every word, and every non-linguistic element of the message in the form of pauses, tone of voice, self-corrections, stumbling, and so forth. So every element of meaning must be preserved, but that does not mean word-for-word interpretation. And as I mentioned before, the style and the tone of the speech are important for everyone in the courtroom to make judgments about the credibility of someone. The proceedings should be able to go ahead as if there were no interpreter there. They should not be unduly disrupted by the fact that an interpreter is there. If the interpreter interrupts the witness to break up their testimony into shorter chunks that are more manageable, that is acceptable and even advisable for an interpreter to do, but it has to be done very carefully, because the manner in which someone speaks depends on their level of power. There is powerful speech and there is powerless speech. And if someone is constantly interrupted and their testimony is given in very short chunks, that makes them appear to be not very knowledgeable. It makes them appear to be thinking in very short bursts. And they're not able to build up the momentum that many speakers like to do when they're describing something. So the interpreter should not be disrupting the flow of the speech and shouldn't be unduly distorting the style of speaking of the person or the relationship between the questioner and the person being questioned. So these interruptions should be kept to a minimum, even though they may be necessary to keep the interpreting accurate. Interpreters do have an obligation, because of this accuracy requirement and the completeness that they're required to observe, they do have an obligation to inform the court if there is anything they did not hear or did not understand or have forgotten in the case of a long answer. So whenever the interpreter hears something that is unfamiliar to them, instead of just asking the witness, could you repeat that, or what do you mean by that? I didn't understand that. What does that word mean? You can't have an independent conversation with a witness in another language. So the interpreter has to inform the court, Your Honor, the witness has used a term the interpreter is not familiar with. Or, Your Honor, could the interpreter have a repetition of the address? Or something very precise like that. And get the permission of the court first and provide full transparency of what it is you're going to be saying to the witness in their language before you do it. And obviously you want to keep that to a minimum. You don't want to be constantly interrupting the proceedings and saying, Your Honor, the interpreter doesn't know this word. Your Honor, the interpreter needs a repetition, because it becomes very cumbersome for everyone. And that's why, other than on the witness stand, simultaneous interpreting is the norm. And rarely do interpreters stand up in court and say, Your Honor, could that be repeated for the benefit of the interpreter? Although if they can't hear, for some reason, if the person who is speaking has his or her back to the table where the interpreter is sitting because they're addressing the jury and the interpreter can't hear, then the interpreter does have an obligation to stand up and say, Your Honor, the interpreter is unable to hear. Or in rare instances, when someone is speaking extremely fast, the interpreter may need to ask the judge to have that person speak more slowly. Court reporters, who are also present in the courtroom taking down everything that is said, are generally the ones who are the kind of the measuring stick. Court reporters have to be able to keep up with speech that is approximately 160 words per minute. And interpreters generally have to be able to keep up with that also. 160 words a minute is very challenging. It's really difficult to maintain that, interpreting at that pace. But anything faster than that, the court reporter undoubtedly will say to the judge, Your Honor, could the speaker be asked to slow down? And interpreters and court reporters are allies in that sense. Interpreters are never allowed to give legal advice. And that is something that seems obvious on the surface. We're not lawyers, we're not trained in the law, so we shouldn't be giving people advice. But sometimes a very innocent question that you know the answer to, you're tempted to answer, but if you did answer that, that would constitute legal advice. If someone says, is this judge really harsh? Or is this attorney representing me well? Do you like this attorney? People often ask interpreters that kind of question because the interpreter is the only one who knows their language, and they view the interpreter as a bridge or even a lifeline. But interpreters have to resist the temptation to answer questions, even if they do have an opinion about it, or they do know what the sentence is likely to be, or anything like that. If they answer questions like that, that is legal advice, and they're not allowed to do that. Interpreters do need to have a full command of both the languages or all the languages they work in. I mentioned the range of registers, everything from street slang to the language of judges and attorneys. But that doesn't mean they know every single word in the universe. Interpreters often encounter terms they don't know, and their obligation is to inform the court and take steps to make sure that the interpretation is accurate by looking something up, by consulting a colleague, or by asking the person who used the term what it means, but always with full transparency. And interpreters should never misrepresent the level of sophistication of the speaker. That is essentially what I was talking about when I indicated that you have to maintain the same register. If you have someone who has a second-grade education and is describing an incident using very poor language, they're not very articulate, they don't have a broad vocabulary, and they may be making grammatical mistakes in their language, interpreters should not clean that up. They shouldn't render it as if it were a normal sentence spoken by someone with a good education. They have to speak the words of that person with a second-grade education, even if it seems like someone will think, in beginning, interpreters often say, well, won't they think I'm that stupid, or won't they think that I'm making those mistakes? No, because they recognize that this is the interpreter's duty. The jury needs to know that this person is very unsophisticated. That's part of what they'll take into consideration when they reach their verdict in the case. And if the interpreter were to raise the level of their language, then that would distort justice. We do have a very strict code of professional responsibility. I'm going to talk about the one that we have in the United States, which is a model code that most of the states have adopted. And I'm sure it's very similar to the one that Canadian court interpreters abide by. And these are the tenets of the Code of Ethics. I will not read all of them. I'm sure the interpreters would not want me to read this thing at a rapid pace, but I will let you read these in your own time. I'll give you a few moments to read through these, and I think you will see that they are fairly obvious, straightforward things that interpreters should be required to do. Do you have a question?
I was just curious about number 6.
Number 6, restriction of public comment. The reason for that is that a lot of times court cases are covered by the press. And newspaper reporters, being the curious souls they are, want to interview people. They want to get background information. They want to get the inside scoop. And interpreters are perfect targets for that. If you've been interpreting for a defendant, they want to know what you think of the person. Do you think he's guilty? How has he been behaving throughout this? And some of these really high-profile cases that happen are all over the news, and you can see that they're just desperate for some sort of story to tell. And if someone were to be able to interview an interpreter, it would be a big scoop. But interpreters have to protect their neutrality. They can't be seen as biased. And if an interpreter were to say in public, I think this judge is being very unfair, or yeah, I think this guy is guilty, then that would ruin the whole case, because they would have a biased interpreter who might have skewed the testimony. So interpreters have to be very careful not to talk about any of the cases they've worked on, even after they're over. I mean, these are public proceedings. It's not that you have to keep them a secret, but you can't express opinions about them because the case could be appealed. And the losing side in the case could say that having a biased interpreter who thought the guy was guilty all along, or who thought the judge was being unfair, is a reason to overturn a conviction. So interpreters do have to be very circumspect about discussing cases. Yes? Number 8, assessing and reporting impediments to performance. That refers to telling the court if you cannot hear or if you cannot see. Someone has an exhibit, they're pointing to a map, and the interpreter is positioned in the courtroom such that they can't see the map, then they need to tell the court that. Or, as I talked about, rapid speech or fatigue. In many of our court systems, we don't have really good working conditions. And court interpreter fatigue is a major issue. The tradition has been for a single interpreter to interpret a full day of court proceedings. And those of you who are conference interpreters know that that's not correct, that interpreters can't maintain accuracy for hours at a time. The courts in my region, in California, are trying to remedy that, and they are assigning 2 interpreters to cases they expect to go for longer than an hour or 2. It doesn't always happen, and there aren't always enough interpreters to be able to do that. So interpreters need to inform the court when they are reaching that point where they can't concentrate anymore and they can't guarantee that they're interpreting accurately. And once an interpreter says that on the record, that could be grounds for appeal. Your Honor, the interpreter is not able to guarantee accuracy because she's been interpreting for 2 hours straight. So the judge would have to give that interpreter a break. It's unfortunate that we don't have the working conditions that most conference interpreters enjoy, but we're slowly but surely remedying that. Yes?
In your estimation, how long should an interpreter interpret? You hear that it's 30 minutes, you hear it's 45 minutes. What do you think?
The question is, how long should an interpreter interpret? 30 minutes, 45 minutes, what should it be? Part of it depends on the nature of the discourse that you're interpreting. If it's fast, dense legal language, I think 30 minutes is the limit to what someone would be able to interpret with extreme accuracy. If it is more casual speech, it may be question and answers that have a lot of pauses in between, then the interpreter would be able to go for longer. But I think if you get up much more than an hour without a break, then you really are sacrificing the quality of the work, and that means that there's no due process. And that's what we always need to remind judges. If you just say, Your Honor, I need a break because I'm tired, they don't necessarily pay attention. But if you say, Your Honor, due process is threatened, then they know they could be overturned on appeal if they are denying due process by having an interpreter work excessively. So We have to learn the right words to say. Any other questions about the Code of Ethics before we move on? As I said, we have an adversarial system of justice, both in Canada and in the United States. And what that means, especially in the United States, I don't know about here, but you've all seen the TV shows. To a certain extent, they do represent what happens in courtrooms. It's a theater production. People are playing their parts. They are reenacting a drama for the benefit of the jury. So lawyers will deliberately ask questions they know will make someone cry or will make someone angry. I often liken it to soap operas, which is one of the things I like about court interpreting, because you hear so many interesting stories. And it's always he said, she said, and he's lying, and she did this, and, you know, really nitty-gritty kinds of personal things. And for a voyeur, it's fascinating. But unfortunately, what I often feel like is that everyone in the court has studied their lines. They have a script and they know what their part is, but the interpreter doesn't. And the interpreter has to play all the parts. You are that prosecuting attorney cross-examining the witness in a very aggressive way. But you are also the witness who is being intimidated and who is getting flustered. You play all the parts without a script. Your impartiality is constantly being tested because each side wants you to render the testimony in a way that benefits them. The prosecutor wants to hear one thing from the witness. The defense wants to hear something else from the witness. The interpreter is a very convenient scapegoat. And because court is theater, attorneys will deliberately blame things on the interpreter they know very well they have nothing to do with the interpretation. Or they will deliberately ask questions that they know are difficult to interpret just because they want that breakdown in communication to happen. It could be that they want to draw the attorney's attention to the fact that there is an interpreter there and there's a language barrier. They're not allowed to call attention to that because everyone has a right to an interpreter and it can't be taken into consideration, but they can certainly remind the jury very subtly that this person requires an interpreter. Or they can point out that the person spoke English on other occasions and now they're using an interpreter, and why is that? These are all things that they are deliberately doing to undermine the credibility of someone. There also is a lot of emotional stress. People do burst into tears. They get very upset. They're testifying about very traumatic events sometimes. Or you interpret for very sad things. You interpret in child custody cases where a parent is having the child taken away from them, or there has been abuse in the home, and you have to interpret testimony about child abuse. It can be very emotional, and interpreters do need to learn professional detachment. They're in a very similar position to psychologists and other people who work in what are called the helping professions, who have to resist getting emotionally involved with the clients they work with. And that's very difficult to do. Trying to convey their words in a very effective way that is an accurate reflection of how they're saying it without taking it personally, taking it in to your own self. So you have to learn to compartmentalize. I mentioned the multiple registers and the speech styles. Adversarial justice means that people come in and tell their story to the court to persuade the court of a certain thing. And that means that they speak in very different ways. They have their own agendas. Someone may be very evasive. Someone may be very effusive. And all of that has to be rendered accurately. And sometimes that's really difficult when two languages don't coincide. There are certain things that are really difficult to convey from one language to another, and interpreters have to be able to deal with that, and immediately. You have to think on your feet and decide, how am I going to handle this? How am I going to render this difficult phrase that doesn't really have an equivalent in the target language? But there are rewards. You do enable people to tell their stories. If someone has been a victim of a crime, they should be able to come forward and tell what happened to them in their own language without feeling that they are denied that because they don't speak the language of the court. And you are there to make that possible, for them to tell what happened. Or if someone has been accused of a crime and they want to tell what their side of the story is, they want to explain what their motivation was, they can only do that if there's an interpreter there. And, you know, it's vicarious thrills. You get to participate in these dramas without it really affecting you. You can go home and sleep in your comfortable bed and live with your nice family and not have to endure the ramifications of any of this, the consequences of it, but you're right in the middle of it. And it can be kind of thrilling. You also get a lot of gratitude. People are really grateful to interpreters for doing a good job. And those compliments never get old. When you've finished a day of testifying on the stand and it was something really gruesome and grueling, and an attorney tells you afterwards, thanks a lot, you did a great job, or anyone else in the courtroom, wow, I know that was tough, you did great, like the court reporters, that's really rewarding. That's one of the reasons we stay in the business. And to a certain extent, you're contributing to justice being done. I wish we were contributing more to justice. There are a lot of things in the justice system that are unjust. And when you see the inside, the inner workings of a court system, you see things that don't always turn out well. But for the most part, you are contributing to making sure that justice is done, and that's rewarding. It's intellectually stimulating. There's always something new, either an interesting legal concept that you didn't know about, or something that is really difficult to render in the target language, and you want to go home and look up more background information to see if you can find a better equivalent than what you came up with on the fly that day. And sometimes interesting legal arguments. You get really interesting little twists on life. I had a case one time with a guy who was ordered to perform community service as part of his sentence. And as his community service, he worked for the city that had vacated this hotel building, and they were preparing the building to be demolished. It was on city property, and they were going to demolish that building and build some new city center or something. So he was working on removing old items from this old hotel, and he decided to steal a shower curtain from the bathroom of one of the hotel rooms. And he injured himself while he was getting this shower curtain, which he was going to steal. So the question was he entitled to workers' compensation because he was working for the city when he injured himself? Was he entitled to compensation when he was committing a crime? I never did hear the outcome of that story, but I thought it was a fascinating legal dilemma. Now I'd like to talk a little bit about research that has been done on court interpreting. I thought that maybe in this audience we might have some people from other fields that are interested in interpreting as an avenue of research in sociolinguistics or psychology or something like that. So I wanted to tell you about some of the studies that have already been done on interpreting. One of them has to do with whether an interpreter is present and should be present, or whether an interpreter is needed. If an interpreter was absent in a given case, is that grounds for appeal? There have been legal studies on the presence or the lack of interpreters, or on incompetent interpreting, and whether or not that was grounds for appeal in a case. And there also have been studies on jury outcomes. How does the jury perceive a case that is interpreted? Does the jury get the same information through an interpreter as it would get if the witness testified in their own language? So what is the effect of having an interpreter there? If there is an interpreter involved in the jury deliberations, we do have interpreters for jurors in some states. It's all over the United States, we have sign language interpreters for deaf jurors, but we also have spoken language Spanish interpreters in some states for jurors. And the role of the interpreter in the jury deliberations is another area that's interesting to research. Interpreters impact on the testimony if they distort the questioning style of the attorney. There are a lot of studies on the pragmatics of questioning, how attorneys ask their questions, and whether they are leading a witness to answer in a certain way by framing the question the way they do. And then when you throw an interpreter into the mix, that adds another layer. So a lot of linguistic studies have been done on the effect of interpreters on cross-examination and direct examination. And the communication dynamics. When you have an interpreter in the room, how does that affect communication? How do people behave differently when they're communicating through an interpreter than they would if they didn't have an interpreter? What is the impact of remote interpreting versus having an interpreter present? There have been studies in medical interpreting that have found that some patients actually prefer to have a remote interpreter because they don't want another person in the room. And they're impressed with the technology. That was something that I found really interesting. In one of the studies, the patients were so thrilled that someone had set up this fancy technology with a TV screen and everything just for them because they didn't speak English. And they were honored by that. But there were other patients from the former Soviet Union who hated it. They were really suspicious of it because they had grown up in a system where they were constantly being watched. And they didn't like having someone in another room who was knowing what they were telling their doctor. So it was really interesting. The effect of fatigue on interpreter accuracy. There have also been studies done on the opinions and attitudes of attorneys who work with interpreters and judges who work with interpreters. Do you change your approach to a case if you're working with an interpreter? Or do you trust interpreters? How do you feel when you know an interpreter has been assigned to your case? And the same with witnesses. When you have to testify through an interpreter, do you feel confident that the interpreter is going to convey your words? Or if you have to rely on an interpreter to convey what's being said in your case, do you feel that you're getting all of the information? And they have interviewed interpreters themselves. What's it like working in these situations, and do you feel that you are respected? Do you feel that people trust you or have confidence in you? If you have stress from the job, do you have adequate means of addressing that? Another study was done on interpreting expert witness testimony. How do interpreters handle the unusual speech patterns of expert witnesses who are often scientists or technicians who are not very articulate? They're not very good speakers. How do interpreters deal with that kind of testimony. The nature of legal language. A lot of legal language is really originally written down on paper and designed to be read by someone, but then it is spoken out loud for oral consumption. Jury instructions, for example, the judge reads the law to the jury to tell them how they're supposed to decide a case, and that's all very complex, dense legal language, which is intended to be read by someone so that you can think about it and process it more slowly, but it's delivered orally. And that really changes the nature of the speech. So those are some studies that have been done. Some studies that have been proposed or that we would like to see include aptitude. Who is the best person to become an interpreter? What kinds of personality traits? What kinds of intellectual capacities? What kinds of mental processing are you looking for as someone who has potential to be an interpreter? How can you determine whether someone is a good interpreter? How do you assess interpreters? Are there certain methods of testing that work and certain methods that don't work? How can you train interpreters? What are the most effective methods? How does a court administration deal with the multiple languages that they have to contend with all the time in a place like Toronto, where you've got probably dozens of different languages? The courts have to provide accurate, qualified interpreting for all those languages. And it may be quite easy in some of the major languages, but for some of the very limited languages of limited diffusion that are spoken only in a few villages in Africa or Latin America, it's very difficult for the courts to meet the same requirements for interpreters in those languages. There are no resources for training, and those individuals don't work full-time at it because there aren't enough jobs for them, so they can't specialize in that. So what are some good ways of managing the resources? What are some approaches that court administrations can take to make sure their needs are met? And when they have someone in one of these rare languages who has no experience interpreting, what can they do to bring them up to the level they need to be for, say, a very important trial that's coming up? And what are the impacts of interpreters on the outcomes of cases? Comparing interpreted and non-interpreted cases in court. Are people more likely to be found guilty or not guilty? Are they likely to comply with the sentencing, the terms of sentencing or the terms of probation? All of these things are fruitful areas for future research that could be done. What else? What are some other things that you think might be subjects or questions for researchers to answer? Either as I've been speaking or things you've been thinking about. Can you think of any other topic that would be good for a research project? Yes?
Well, you'd have to probably study the actual, I guess, defendants or plaintiffs that are actually on the stand, because I'm pretty sure that they would have maybe effect on the interpreters as well.
Ask about the people who don't speak the language of the court and what their effect on the interpreters is?
That would probably be an option that probably maybe overlooked that could have a strong effect on it.
So how does an interpreter respond depending on the person they're interpreting for? That's a very good point. And gender issues, it just occurred to me. If a female is interpreting for a male or a male interpreting for a female, how does that affect both of them? And age differences, too. A very young interpreter with an elderly person or vice versa. That would be interesting.
Where is this research being done?
Where is the research being done? Everywhere, all over the world, really. At universities, primarily it's scholars at universities. And there are many journals that publish the results of these studies, yes. Interpreter education journals, interpreting and translating in specific fields, forensic linguistics, all kinds of specialized journals that either specialize in interpreting per se or often publish articles that involve studies of interpreting.
The one about aptitude for interpreters sounds really interesting.
Mm-hmm.
Like what, if you're born an interpreter or you learn to be
Mm-hmm.
an interpreter?
There have been quite a few articles written on just that question. Are interpreters born or made? I think we've concluded that they're made.
Good.
But you have to be born with certain aptitudes. The question is, what are those aptitudes?
And can you elaborate a little bit on that or no?
On the answer
On
to
the
the questions, aptitudes. Well, I think it is generally agreed that interpreters have to have good speaking skills, they have to have a good memory, they have to have a curious mind, they have to be a quick study so that they can bone up on a topic and then be prepared to interpret on it. They have to be able to work under pressure. I think those are generally accepted ideas, but there may be a lot of other things that we don't know about or that are counterintuitive. What is the correlation between musical ability and interpreting? A lot of interpreters tend to be musicians. Why is that? A lot of things like that.
Cool.
Yes.
And another research question, which may be very futuristic as well, but is there any role, or will there ever be a role for computer-assisted interpretation, for example? Like the military is studying applications of that, and they're using it in very basic ways in Afghanistan.
Mm-hmm. The question is, will there ever be a role for computer-aided interpreting, right? It is already, I mean, interpreters use computers in their work all the time. They have portable devices that they use for research and that kind of thing, and voice recognition technology is getting better and better. I think that for the kind of work that you see done in court, that's going to be extremely difficult. I think there is already a lot of automated interpretation of very fixed messages. Certain questions and answers that are repeated over and over again. I think the police are carrying around these little devices that, like they call them portable translators or something. But that's only for a very limited set of or a limited field of communication, and once anybody strays from that, the computer doesn't know how to deal with it. And in the case of court, you have a lot of people with very different speech styles, different regional accents. As a Spanish interpreter, I know that there's a huge variety of speech that is used by the speakers, and you often have people who aren't well educated and who have their own idiolects. They use words in strange ways that you would never find in any kind of dictionary or grammar or anything. Just individual quirks. Could a computer deal with that? Computers, I'm getting the two terms mixed up. Computers are incredibly impressive in what they can do. And that computer that beat the Jeopardy guy was pretty amazing. But I'm not worried that we'll be replaced by computers. What I am worried about is having everything outsourced and being done remotely. That's happening more and more. Yes?
Yeah, I think also what's happening, or what's going to be somehow should be emerging, is that the world is becoming a kind of multilingual, translingual, compared to what used to be like monolingual. And I think our education system needs to incorporate kind of interpreting skills within our students, whether they are interpreter or not only for linguistic proficiency, to generalize the skills of interpreting and translating to other disciplines, because the world is becoming really translingual, and the linguistic super diversity is making people miscommunication, misunderstanding.
So if I can sum up your comment, I think that I'm understanding that you're saying that with the world becoming increasingly multilingual, more and more people need interpreting skills for their jobs who are not specialists in interpreting. But if you go into business, for example, or you practice medicine, you occasionally find yourself interpreting. Is that what you're saying?
No,
that
I think even doctors, business people, administrators needs to kind of have kind of interpretive skills to be able to make sense of their daily encounters, rather than just only communication.
They need to have interpreting skills to make sense of their daily encounters. I think they need language skills and intercultural skills. I'm not sure how interpreting applies
Because
to that.
culture is interpretation. When I'm working with someone from different culture, I'm not only communicating, I'm interpreting that culture based on my cultural knowledge. So what I'm saying is that in industrial days, things were communication, bureaucracies, but now on a daily basis you have to encounter with things that you never imagined in your daily life. So you want to make sense out of it. So you
Okay, people are encountering all these new situations and they need to make sense out of them, and in that sense they need to interpret them. The word interpret is really interesting because it has so many meanings, and one reason why court interpreters, I think, have not been accepted well in the court system is that judges feel that they're the ones who interpret. Judges interpret the law. And when someone else comes in and says, I'm here to interpret, they don't trust us because they think we are skewing things in our own way, in the sense of interpreting things, putting your own sense of what it means. And they prefer to call us translators, partly for that reason, partly out of ignorance. But I think they don't want to yield their ability to interpret to anyone else. And interpret does mean to them figuring out your own meaning for something, deciding for yourself what it really means, and they don't want interpreters doing that. So it's an unfortunate coincidences of meaning of the word, or different meanings that the word interpret has. And in Spanish, interpret also is used for acting and singing and portraying things. So there's another juxtaposition of meanings that sometimes is unfortunate. Are there any other questions or comments? Yes.
So we can give general.
Yes.
Here, okay.
Yes.
More questions. A question about the continuous education or professional development you had mentioned there is point number 10. I know in a lot of states in the U.S. there's requirements to keep, your certification. You need to have that. In Ontario, there happens not to be any such requirement. How would you go about? How would they go about, setting something up? Or what are some of the models that work in the U.S. for professional development?
The question is about continuing education and professional development, and how would you go about implementing that requirement in a place where it doesn't exist yet? Is that basically what your question is? I think you follow the model of other professions, because most professionals do have continuing education requirements. And in our field, in California, they allow us to get credit for anything that would be granted legal continuing education credit. So the things that the classes that lawyers take for their continuing education are automatically given credit for ours. But there are obviously unique needs that interpreters have. And a lot of it is language maintenance, which is not something that someone else would be interested in, but anything related to language, slang, the language of a specific field, or even the interpretation of literature and the use of language in a certain author's writing or something like that could be relevant for interpreting. The professional associations, I think, have really taken the lead in offering the education itself, whether the official entities recognize it or not. You have a professional association here, right, of más o menos?
We do, yeah.
Well, I think you would need to push the professional association to start doing it. And actually, it can be a source of revenue for the professional association or for anybody else. We've created an industry now in the U.S. of continuing education providers because so many people have to get their units in. And unfortunately, some of them regard it as just that. I need 6 hours. I don't care what they are. I just got to get in my 6 hours before the reporting deadline. But most of us aren't that cynical. But it can be a means of earning an income. Yes?
In court interpreting, is there any person or process that afterwards checks the accuracy and quality of that interpreting or that interaction in general to make sure there wasn't, for example, a critical decision made by the court that wouldn't have been made if the interpretation were different or say more accurate?
The question is there any means of checking after the fact on the accuracy of an interpretation and any way of correcting it or counteracting it? No. Because we have oral court proceedings that are then taken down into a written record, the English that was provided in the court by the interpreter goes into the record. There is no recording of the source language that the interpreter was coming from, except that there could be an audio recording of it, but it's not permanently kept. Someone would have to go through, get an audio recording, and try to identify that language in the middle of everything else that was going on in the courtroom, separate that out, transcribe it, and then compare it with the interpretation. On the other hand, the interpretation that is provided into the other language for a defendant, it's whispered interpreting, and it's off the record, and it's confidential. I mean, a lot of times they're sitting next to their attorney and talking with their attorney on occasion, which is privileged information. So there definitely would never be a record of that. And that's why our job is so important, because we do have this power that we need to use wisely, because we can affect the outcome of a case. The only thing I know of is some court systems have a supervisor who goes around to monitor interpreters, but it's very sporadic, and it depends on that supervisor's language knowledge. They're not going to be able to monitor people whose language they don't speak. So basically the answer is no. Anything else? Yes?
I have a few more questions. One is on how widely used are electronic resources in the courtroom, and how widely accepted is that among the judges? Can I just look at my e-dictionary? Is that?
Yes, it's always acceptable for an interpreter to use an electronic resource in the sense of a dictionary. Interpreters should always have dictionaries with them, just in case. But the issue of getting on the internet in the courtroom to do research is debatable. A lot of courtrooms don't allow anyone to have internet access while they're in the courtroom. People have to turn cell phones off. But the judges and the lawyers have their iPads there. I mean, everybody is using computer resources, so there is nothing wrong with an interpreter having that. It's just that you may not be able to get on the internet to do extensive research. And I think that's getting more and more common. Another use of electronic devices that is coming into vogue now is SimConsec. And that is using a digital recorder or a digital pen that has a camera and a recorder in the pen, and the interpreter, for consecutive interpreting, they take notes, but the pen is also recording what's being said so they can play it back in their ear. And a lot of courts have not accepted that because you're making your own independent recording of the proceedings. And it'll take some persuading to get judges to accept that in the courtroom. But I think that's in the near future. That's going to be happening. Do you know anything about the use of SimConsec here? Is it not prevalent?
Everything we know about it comes from the U.S.
Yeah, I think in Europe it's also being used a little bit, but it's very gradual.
I've certainly heard Hans Kuchek talk about
Yeah,
it.
yeah. I think everybody is getting more and more wired. Yes. Yes.
Yeah. A while ago, you mentioned that the judges and the attorneys use iPads and so on.
Mm-hmm.
And you talk about electronic resources. But isn't it that those frequencies can be picked up by the recording microphones and interfering?
The question is, the frequencies of the electronic devices could be picked up by the microphones and cause interference. Is that it? If it's infrared, or it depends on what the audio system in the courtroom is. If it's hardwired, there's not going to be any interference, and it depends on what means they have of communicating. I think judges and court clerks tend to have now computer consoles right there on the bench, and they are internally connected to the court computer system. But whether they are connected to the internet in the courtroom, I don't know. And I think there would be no interference if it were their internal network that they were connected to. One more?
You mentioned your concerns also about outsourcing, and what came to mind is the UK situation of our colleagues there who are currently, their work has been outsourced. I don't know if maybe you could just touch a little bit on that, and do you see that possibly happening in US or Canada?
Well, to a certain extent, the question is, do I see coming to the US or Canada what has been happening in the UK with the outsourcing of interpreters? I think that the more common something becomes, the more people look to cut corners and to save money on it. When interpreting was a rarity, nobody really noticed how much was spent on it because it was so little compared to other things. As it becomes more and more a part of daily life, the bean counters start looking at it and saying, wait a minute, we're spending a lot on this. We could put out a bid and award the contract to the lowest bidders. And that's what's happening. So agencies are bidding on contracts with court systems. That's what happened in the UK, and that's what happened in Spain. And probably a lot of other countries. And in some jurisdictions in the US, that's the way it's done too. And the agency claims that they will get qualified interpreters, certified interpreters in the languages that are certified, but they don't always do it. They just send an interpreter there, and everyone assumes that if the agency sent them, they must be qualified, and they aren't always. The courts are also using a lot more telephone interpreting or video interpreting to save money. And some of the big providers of telephone interpreting are outsourcing to other countries. So with Spanish, they have call centers in Peru and Costa Rica and Argentina. And so the interpreter may not live in this country. They may not have any sense of how the U.S. or Canadian court system works.
And they may not have any training either.
They may not have any training, yeah. So it's, I'm afraid that that is a growing trend, that interpreting is becoming commoditized. Yes?
What advice do you have for students who aspire to be legal interpreters? And what related work experiences should one have before applying to, say, the Ministry of the Attorney General, which we have in Monterey?
Okay. What recommendations do I have for student interpreters who might want to become court interpreters, and what work experience should they have before they apply? I think that you do need to become a certified interpreter. Here in Ontario, there is a specific certification for the Ontario courts. And to prepare for that, to get the work experience you need, you can interpret for law firms in attorney-client interviews and legal clinics where people are discussing legal issues. If they, some of them will have paid positions and some of them rely on volunteers if it's a free clinic. But that's good experience for you to get. And working in other public agencies as an interpreter, as a freelance, where certification is not required. With the interpreting training you're getting here, you're probably much better than the interpreters they've been working with. Unfortunately, they don't pay very well either, but it's very good experience to work for some of the public agencies that hold hearings or that have to have client interviews through interpreters, and that's good preparation for it. And eventually becoming certified for Ontario and the CTIC certification so that you can interpret in other provinces too. Even though you'll get a degree here, that certification is an added bonus. It just makes you that much more marketable. Thank you all very much.
All right, I'm just going to do an absolutely a shameless plug for the Master of Conference Interpreting, because it ties in nicely with the last question. As part of the first year of our program, we do include actually 72 hours of training specifically in court interpreting, and I can vouch for the fact that in our court interpreting classes, one of the textbooks that's used very, very often was written by you, Holly. So with that in mind, I just want to ask all of you gathered here today to help me thank Holly for being so generous with her thinking and for taking us through this very thorough and clear tour of court interpreting. Thank you very much.